Welcome to this explainer. Today, we are dissecting a totally fascinating, high-stakes legal drama, and it's centered entirely around a ticking clock. We're looking at Constitutional Court Case CCT 10/04. This was a massive, landmark dispute that erupted in South Africa right before the 2004 national elections. It is literally a brilliant case study in administrative law, constitutional rights, and honestly the absolute, unforgiving nature of a deadline.
Okay, let's jump right into this. I want you to consider a seemingly microscopic number, 21. I mean, in the grand scheme of running an entire country, organizing millions of voters, printing all those massive ballots, 21 is a blip, right? It's the length of a quick coffee break.
But this brings us to the core mystery of this whole case. What difference does 21 minutes actually make in a national election? Well, as it turns out, that tiny window of time triggered a massive constitutional battle that went all the way to the absolute highest court in South Africa. Let's see exactly how those 21 minutes changed the course for an entire political party.
Section 1. The 21-minute mistake. The incident.
To understand how this happened, we have to look at the applicant in this case, the Liberal Party. In early 2004, they were the newcomers to the political scene. According to the court records, they had very limited resources and they were initially just completely unaware of the complex formalities required to register and actually participate in the upcoming April elections. So they were scrambling. Every single political party contesting the election was required to submit their candidate list to the Electoral Commission by a very specific date and time. And the margins of error here are wild. The final deadline set by the election timetable was 17 o'clock or 5 p.m. on February 27, 2004. The Liberal Party arrived and tried to submit their list at 17:21, exactly 21 minutes late. The Electoral Commission refused to accept it, which effectively blocked them from the ballot entirely.
Section 2. Escalating to the highest court. A race against time.
What followed was just a frantic legal scramble. I mean, the Liberal Party didn't just throw their hands up and accept defeat, they escalated the issue. First, they approached the Electoral Court, which dismissed their appeal without even detailing reasons. So then, they urgently petitioned the Constitutional Court of South Africa directly. And the time pressure here was just immense for everyone involved. The Liberal Party officially registered on February 19th. The submission deadline was a mere 8 days later on February 27th. They spent all of March firing off these urgent appeals and letters, fully aware that the fixed, totally immovable National Election Day was looming right around the corner on April 14th. The Constitutional Court had to hear and decide this case with incredible speed, and they ultimately delivered their judgment less than 2 weeks before voters actually went to the polls.
Now, in their urgent application, the Liberal Party wasn't just asking for a slight bend of the rules. The scope of legal relief they wanted was massive. They wanted the court to order the commission to issue their registration certificate, grant them the right to contest, grant exemptions from the laws, and incredibly, they even asked for a full postponement of the national elections so they could stage a quote-unquote mini-campaign. The Constitutional Court quickly debunked one of their primary complaints right out of the gate, though. The applicant claimed they hadn't been given a registration certificate, but the court noted the commission had, in fact, registered the party and published it in the Government Gazette back on February 19th. So the real issue wasn't the registration at all. It was that late candidates list.
Section 3. Breaking down the law. The legal crux. So you might be wondering, why was the Electoral Commission being so incredibly stubborn about just 21 minutes? To grasp that, we need to shift our focus to the actual laws governing the electoral process. The governing rule here is Section 27, subsection 1 of the Electoral Act. It clearly states that a registered party intending to contest an election must submit its list of candidates to the Chief Electoral Officer by not later than the relevant date stated in the election timetable. The court really emphasized that specific phrase, by not later than. It's a strict, mandatory requirement. There is absolutely no language in Section 27 suggesting the Commission has the discretion to just say, you're close enough, come on in.
And this brilliantly illustrates the core legal distinction the Liberal Party completely failed to understand. The party argued that the Commission actually did have the power to help them, and they pointed to the very next section of the law, Section 28. Section 28 allows the Chief Electoral Officer to notify a party if they haven't fully complied with the rules, and it gives them a specific window to rectify their mistakes.
But the Constitutional Court completely shut down this argument with some pristine logic. Section 28 explicitly begins with the condition, if a registered party that has submitted a list of candidates has not fully complied. Do you catch that? The crucial point is that Section 28 is for fixing mistakes on a form that was handed in on time under Section 27. It doesn't give the Commission some magical discretion to condone a completely late submission. Simply put, you cannot rectify a form that was never submitted in the first place.
Section 4. The discrimination claim. Unequal treatment?
Realizing the law wasn't on their side regarding the deadline, the Liberal Party pivoted to a brand new argument. They claimed they were victims of discrimination. They essentially alleged that the Electoral Commission was playing favorites, allowing other political parties to fix their mistakes while denying the Liberal Party that exact same concession. They specifically pointed to the Peace and Development Party, or PDP. But when the court actually looked at the facts, the comparison fell completely flat. The Liberal Party missed the mandatory deadline by 21 minutes. The PDP, on the other hand, submitted their candidates list prior to the 1700 deadline. Their issue was just a dispute over whether their required deposit could be tendered via a bank-guaranteed check deposited directly into the Commission's account. And crucially, that was settled prior to the 1700 cutoff. So the court ruled this wasn't discrimination at all. It was a totally different factual circumstance. The PDP met the deadline, the Liberal Party didn't.
Section 5. Protecting the election timetable. The macro stakes.
Let's zoom out to the bigger picture for a second. Why is the Constitutional Court so obsessed with this strict timetable? Is it just bureaucratic red tape, or is there a fundamental democratic principle at stake here? Well, the only way the Commission could legally accept the Liberal Party's late submission would be to officially change the entire election timetable under Section 20 of the Electoral Act. But look at the rigorous steps required to do that. The Commission must first consult the Party National Liaison Committee. Then, they have to publish the amendment in the Government Gazette. And most importantly, they can only do this if it is strictly necessary for a free and fair election.
Furthermore, there's a massive constitutional reality sitting at the end of this timetable. The President sets the final election date. The Electoral Commission cannot change it, period. Therefore, if the Commission extends a deadline for one party, it eats into the finite preparation time before the President's fixed election date. The court noted that this would place the Commission under increased strain, and it would prejudice the election buildups of every single other party that actually followed the rules.
Section 6. The final judgment. The court's ruling. All of this brings us to the climax of the case. On April 5, 2004, just 9 days before the national election, a unified constitutional court delivered its final judgment. The court dismissed the application in its entirety, and the rationale was brilliantly summarized in this quote from the judgment. Changing the election timetable to accommodate the applicant's late submission is not necessary for a free and fair election. The justices recognized that bending the rules to save one unprepared party from its own mistake would actually threaten the integrity, the fairness, and the strict logistical choreography required to run a democratic election for an entire nation. The consultative process that built the timetable had to be respected.
So the Liberal Party was kept off the ballot, all for being 21 minutes late. It's a really harsh reality, and it leaves us with a profound question to ponder. If a free and fair democracy relies on such incredibly rigid administrative rules to function smoothly, where exactly is the room for human error? Or perhaps, when the stakes are the governance of a nation, is there simply no room for error at all? Thank you so much for exploring this fascinating case with me today.